part of the problem I discussed in the answer to the prior question. If a creditor files frivolous pleadings, the creditor is subject to sanctions because, in essence, what you're doing is wasting the court's time and you're causing the debtor to have to expend costs and attorney's fees in defense. Now, just because I say the lawsuit that you filed is frivolous doesn't necessarily make it frivolous. I'm going to have to establish that. But if I can, then that creditor has opened itself up to having to pay damages. So what sort of thing can constitute a frivolous adversary proceeding? Well, let's take one simple example. Debtor incurred debt to creditor, and the creditor says that debt was incurred through fraud because he's not paying me back. Okay, how is that fraud? I mean, debts, generally speaking, that are being discharged in bankruptcy are debts that haven't been repaid. Well, because he's a bad guy. Okay, so the creditor files the adversary complaint and says this debt should be accepted from discharge based on fraud. Well, that being the case, if the creditor isn't substantially justified in the argument that's being made, the court can sanction the creditor, and that is found in Section 523D, where it says that, and I'm going to paraphrase, if a creditor has sought denial of discharge of a particular debt under a theory of fraud, and the creditor's claim is not substantially justified, then the debtor can get costs and attorney's fees. So there's one direction that the creditor can be hit for filing a frivolous action. Another does place a burden on the debtor. When someone files a frivolous pleading in bankruptcy court, the creditor can appeal to Rule 9011, and there is an analog that's Rule 11 in the Federal Rules of Civil Procedure. It's 9011 in the Federal Rules of Bankruptcy Procedure. And there, if a creditor files a frivolous pleading, the court can grant sanctions to the debtor against that creditor. But there's a little bit of a wrinkle there, and that is when the creditor files the frivolous pleading, the debtor has to send the creditor a motion to have this pleading withdrawn, along with a letter saying this is a frivolous pleading, and under Rule 9011, I am challenging its legitimacy. And the creditor then has 21 days to withdraw the pleading. If the creditor has stuck by its guns and won't withdraw the pleading after the 21 days, then the debtor can get sanctions. But, and I've had this happen, the creditor files these frivolous pleadings, we do the 21-day safe harbor letter, the creditor withdraws it, files another one, do the 21-day safe harbor, and you end up with a lot of unnecessary work. At that point, I'd certainly go before the bankruptcy judge and say, Your Honor, we've got these frivolous pleadings. In each case, the creditor did withdraw the pleading before the 21-day safe harbor had expired, but this is a pattern, and you can probably convince the bankruptcy judge that there has been an abusive process. And in that situation, what I would do is file a motion for an order to show cause why the creditor shouldn't be sanctioned for filing frivolous pleadings. Long and short of it is, if a creditor does that, it can come back to bite that creditor. So you want to be careful when you file adversary complaints that you really do have a good cause of action and you're not just trying to pester somebody.